Before we can look at the Hawaii Rule of Professional Conduct relating to unauthorized practice of law, we have to look at the statutes. And that's because this is one area in which the legislature has firmly established a law. And we're looking at Hawaii Revised Statute, HRS Section 605-14 right now, entitled The Unauthorized Practice of Law Prohibited. And it says, it shall be unlawful for any person to engage in or attempt to engage in or offer to engage in the practice of law, or do anything or attempt to do anything that constitutes the practice of law, except and to the extent that the person, firm, or association is licensed or authorized to do so by the appropriate court, agency, or office, or by a statute of the state or the United States. So this is the statutory background for saying that people can't commit the unauthorized practice of law. Because think about it, the rules of professional conduct only apply to people who are lawyers. They don't have any jurisdiction over people who aren't lawyers. So the legislature had to step in and say, you people without law degrees, you may not practice law. So it's a statutory violation if people do that. Now that you have the background, we can move to the Hawaii Rule of Professional Conduct, because to the extent you'll be working as a paralegal, you will be working with an attorney. And so it's really important for you to understand how the statute we just read plays into your scope of business and the attorney's responsibilities. So now we're back at the HRPC, looking at Rule 5.3, Responsibilities Regarding Non-Lawyer Assistants. And the reason that this says non-lawyer assistants rather than just paralegals is because lawyers work with a variety of people. They work with secretaries, they work with law student interns, they work with document clerks, they work with messengers who run the files down to the courts. So this term encompasses all of those plus paralegals. So let's take a look at the rule. With respect to a non-lawyer employed or retained by or associated with a lawyer, you've got 3 paragraphs here, A, B, and C. And A refers to a specific type of lawyer who's going to be on the hook for the non-lawyer's bad behavior. It says, a partner in a firm who individually or together with other lawyers possesses comparable managerial authority in a firm, so a partner or somebody who has that type of authority, shall make reasonable efforts to ensure that the firm has in effect measures giving reasonable assurance that the person's conduct, meaning the non-lawyer assistant's conduct, is compatible with the professional obligations of the lawyer. Well, that's really a mouthful, but it's easy enough to handle if you break it down. This is saying that the partner has to make sure that the firm has some kind of practice, that's measures that's referred to here, that give reasonable assurance that all of their non-lawyer assistants don't violate the Hawaii Rules of Professional Conduct, because the lawyer can't do it, and so the lawyer can't use one of their agents or employees to do it for them. Now, B is a different type of responsibility for a different type of lawyer. It says, a lawyer having direct supervisory authority over the non-lawyer shall make reasonable efforts to ensure that the person's conduct is compatible with the professional obligations of the lawyer. The difference is that not everybody in a law firm is a partner. A partner is someone with special managerial authority. When I was in a law firm, starting out, for example, I was not a partner, I was an associate. So the purpose of this second paragraph, B, is to make sure associates like me also take responsibility for their non-lawyer assistants. If I had direct supervisory authority over the paralegal I'm working with, it's all of a sudden my responsibility, in addition to the partners, of making sure that person knows the ethical rules. So A gets the partners, B gets the people who directly work with the paralegal. And C sums it all up. A lawyer shall be responsible for the conduct of such person, that means the non-lawyer assistants, that would be a violation of the rules of professional conduct if engaged by the lawyer. So again, this is imputing the bad actions of the assistants to the lawyers. If the lawyer orders, or with specific knowledge of the conduct, ratifies the conduct involved. Now that's a different statement. If a lawyer tells the paralegal to violate confidentiality, that lawyer is totally responsible for what the paralegal does. What does with knowledge of the specific conduct ratifies the conduct involved? Well, let's say that the lawyer does not order the paralegal to do something that's not proper, such as passing out business cards to a total stranger at the scene of an accident. We know that lawyers can't do that. Well, a lawyer may not be ordering their paralegal to do that, but if they see their paralegal doing that, it is their responsibility to tell the paralegal to stop. They are ratifying the paralegal's action. In other words, ratifying is adopting it by knowing what's happening and remaining silent. So this says if you know what's going on and you don't take steps to stop it, you're ratifying it, so you will be responsible for the bad conduct too. And 2 just sums up what we read in A and B. If the lawyer is a partner or has comparable managerial authority or has direct supervisory authority over the person and knows of the conduct when the consequences could be avoided or mitigated but fails to take reasonable remedial action. Again, going back to the ambulance chasing scenario, this means if they see something going on, even if they didn't directly ask for it, they have a duty to stop it and to rectify it, to make it right, to mitigate it, to make it better. And that's how the statutes play into Rule 5.3, and that's how both of those would apply to paralegals.